And we're back, this time with the candidates running for Spokane County Prosecutor. I'm Kristi Gorenson, the moderator for this debate. The Spokane County Prosecutor's race has no incumbent, making this the first time in 16 years the county will have a new prosecutor. The candidates in the race are Democrat Breean, a private practice attorney specializing in civil rights cases. Mr. Beggs previously served as executive director at Spokane's Center for Justice. Next, Republican Larry Haskell, with 16 years experience in the prosecutor's office trying criminal cases. Mr. Haskell is a deputy prosecutor where he currently serves in the gang unit. Welcome to you both.
Thank you.
Thank you.
Well, for this debate, the candidates have agreed to follow our debate rules. We'll put them up on the screen one more time so you can see them. The candidates will have 1 minute for answers. Each candidate can use up to 2 rebuttals during the debate. Rebuttal length will be limited to 30 seconds. For this debate, the candidates will answer questions from a panel of Spokane journalists. And joining us again are Shawn Chitnis from KREM 2 News, Melissa Luck from KXLY News 4, and Kip Hill from the Spokesman Review. So let's begin. A coin flip determined that Mr. Haskell, you'll have the opportunity to answer the first question first. And Shawn, you can take it away.
Kristi, thank you. Candidates, we want to begin by talking about how you can engage the public, especially when there are some who may not understand the role of the prosecutor, and how you can help them to better understand the decisions you would make in that role.
Actually, that process has already begun. In terms of doorbelling and talking to the county residents, there's a lot of people I talk to that say, gee, you know, I don't really know what the county prosecutor does. Tell me what the county prosecutor does. So that process has already begun as I've been going around the county. But by way of being elected, I think the county prosecutor has an incredibly important role in communicating with the public, being responsive to the media, and educating the public not only about what the role of the county prosecutor is, but more than that, to talk about the decisions that we make and to talk about the reasons why we make them, the law that they're based on. So in order to do that, again, very responsive to the media, and also to meet with the various neighborhood leaders and go to the community centers in each of the areas, and to actually be more visible and more responsive that way. And also, I'd like a column in the newspaper as well.
All right, Mr. Beggs.
So the county prosecutor is the chief legal officer for the entire county. We handle the criminal side. We also handle the civil side. Just an article in today's paper about the clean water plant having some problems. I've been the go-to person for Spokane media for several years. When they've got a legal question, you can Google me and you can find out that TV, radio, and news reporters interview me when they have a question. And I provide answers and have for years. If I'm the elected prosecutor, I'll do the same. I'll have even a better platform to do it, because I'll be the chief spokesperson for the county prosecutor's office. And when people have concerns and questions, they'll come to me. I'll be at the office. I'll answer those questions. And we'll get out of front when there's some controversy. So at least the people know what is happening. And if we've made mistakes somehow in the county, we'll tell you how we're going to fix them.
Okay, thank you. And Mr. Beggs, you'll take this next question first. Melissa?
The question to both of you is about courtroom experience and what you plan to do. Steve Tucker hasn't spent much time in front of a jury, in at least the time that I've been here in Spokane. I'd like to know what you plan to do, what leadership style you would have as far as being the prosecutor and trying cases. And also for you, Mr. Beggs, the last time you were in front of a jury, most of us don't know that.
Sure. So I started out doing criminal law when I was a young lawyer back in the early 1990s, and I won a lot of criminal trials, and I've argued cases all the way to the state Supreme Court numerous times. As the prosecutor, I would not be doing trials day to day, because my job is to run an office of 65 attorneys and a lot more employees. And if I'm taking time off to do a case, although I'm sure I would do a good job at it, I'm taken away from leadership. But I will be in the courtroom watching other trials and our prosecutors and performance so that they know what's going on. My last jury trial was a year ago, and it had to do with a case of a police dog biting someone and taking off his ear. And the question was whether or not the police would be held liable for that or not. And the case is currently up at the Court of Appeals, and we're waiting for that decision. I've done tons of arbitrations, tons of mediations, tons of arguments, all different kinds. And I've been recognized as a great trial lawyer throughout the state. And I look forward to coaching and inspiring my officers to do the same.
All right. Mr. Haskell?
This is one area where my opponent and I have a bit of a disagreement in terms of what the role should be. I don't consider trying a case taking time off. The fact is that you can still manage an office of 135 people, including approximately 65 lawyers, and still try an occasional case, if you have the experience to try criminal cases, which I know that my opponent does not. So what I've told people before in other forums is I will try an occasional case. I'm not a headline grabber, but I think it's very important for, number one, the public to see the prosecuting attorney in the courtroom. In many of the smaller counties, it's not an event, if you will. It's part of what they do because their staff is so much smaller. But nonetheless, it's very important for the public to see you doing that, to know that you're competent enough to do that you're confident enough to do that. It's important for the judges to see you there, and it's very important that your deputies see you in there as well. So I will make sure that I take the time to do that in addition to all my management duties.
All right, and Mr. Beggs, you would like to use a rebuttal?
Yeah, I realize it was before my opponent went to law school, but I did a couple dozen criminal trials in my early years back in the 1990s, won most of them, and have argued cases all the way to the Supreme Court on criminal justice. I know how to win trials, and I've won millions of dollars for crime victims in the civil arena in addition to doing criminal trials. And so the question is, where do you want your leadership? Do you want them coaching and inspiring great trial lawyers that you already have, or do you want them off in a courtroom? I will, if it's at the Supreme Court, I will go there because I'm a great appellate lawyer and I'll win that case for the county.
All right, let's see. Mr. Haskell, you will take this question, the next question first. And Kip?
Thanks, Kristi. As a crime reporter, I continue to see affidavits and investigations around marijuana and production of marijuana. Can you explain to the public, what the law is in terms of what is actually a felony if you have any marijuana or producing marijuana, and what would you look for in an investigation that comes to you that has elements of marijuana in it?
Well, the marijuana laws, basically, as I view it right now, in approximately 3 stages. You have the illegally obtained marijuana, which if it's more than 40 grams, it's a felony. You have the newer law that passed a year or so ago that allows marijuana, if you're over 21, purchased from a licensed dealer and you smoke it where you're supposed to smoke it, in your home or in the curtilage area. And then, of course, we still have the medical marijuana law on the book as well. And if you have a certificate, a license, then you're legal to have marijuana in that manner. So the prosecuting attorney will enforce the law. I will enforce the law as it currently is. If it's obtained illegally, I will prosecute. If it's smoked illegally, I will prosecute. And if you're driving under the influence of marijuana, I will prosecute that as well. But beyond that, those are the 3 stages, if you will, areas of the law that affect marijuana use in our state currently.
All right, Mr. Beggs.
So I would have 3 priorities in terms of marijuana prosecution. The first is anyone that's supplying it to minors. We know how dangerous that is. Their brains are not fully developed. And with this new legalization in Washington, that really is the big fear. Is it just going to open the floodgates? So people who sell to minors, that would be my top priority. My second top priority would be driving impaired. When people are driving impaired, they are putting all of us at great risk. And so we need to make sure that that's controlled. And the third is if there is an enterprise of people that are really selling illegal marijuana on a large scale in our community and trying to upset this entire system that we are experimenting with. The system doesn't work as far as legally buying it and distributing it and collecting the taxes that we can then use to help with drug addiction if there's a whole black market out there. And so it's going to be interesting that people are really going to support prosecution for drug dealers because it undercuts our whole system that we're experimenting with.
All right, Mr. Beggs, you'll answer this next question first. Shawn?
Candidates, we want to talk about some cases that have been in the news recently. The one I'm going to bring up is Preston Marr, who was a teenager facing a vehicular homicide case. And as you know, he was given a sentence of weeks in detention for that as the driver of that car where 2 young teens were killed. Many people in the public were confused by that decision and by the plea that was made. Do you support that, and how would you go about explaining that to the public?
I was not an attorney on the case, and I didn't get into all the details of it, so I'm going to give some deference to the judge and the attorneys that were on it. But I think the reason why it's so disturbing is that he only got a few weeks for the loss of some lives, and there are other crimes where people spend far more time, and that's not there. And sometimes in the criminal justice system, there's a crime that is so disturbing to the general public that we want an example set. And I think that's probably a case where we could have done that, where we could have said, yes, you're a good person and you're reformable and that's good, but we need to set an example for all the youth that are out driving out there and that might be tempted to take a flyer, so to speak, and underestimate what the consequences are. I can't second guess exactly what happened, but I share that concern. And the one thing that was most disturbing is that when the elected prosecutor was asked about it, he knew more about the defendant's life and didn't know the victim's first name. That would have to change in my office.
All right, Mr. Haskell.
Well, I would certainly agree that the prosecuting attorney should know more about the case. And if I'm elected the county prosecutor, particularly when I'm addressing family members, I'll know everything possible about the case. And I would also make sure that I had the actual prosecutor that was prosecuting the case in the room with me to make sure that we didn't miss anything. In this particular case, I wasn't involved in it at all, but I will tell you this, as shocking as it may seem, for a felony, a first felony, the judges have the option of imposing what they call the first offender option. And the first offender option gives a criminal defendant 0 to 90 days in jail. And it was clear that this is what was worked out, and that's what the judge imposed. I was also informed that Mr. Beggs was the retained civil attorney for the victim in this case, and that he actually recommended 0 time. But nonetheless, what was given was within the law. It isn't what I would have pushed for, but it was what the parties agreed to. The judge had the authority to go outside of that, but chose not to.
All right, let's move on to the next question.
Talking about another specific case that's been in the news, but was a little bit more within the prosecutor's office. The case of Mariah Wright, a deputy prosecutor who was accused of misconduct because of her involvement with a known criminal who literally had criminal tattooed on his forehead. Part of the frustration there for the media and the community that we serve as well is that the prosecutor's office never made a statement, never came forward to defend or to condemn their attorney. How would you do that differently if you were the elected prosecutor?
Mr. Haskell, you will answer this one first.
In this particular case, there were some unique circumstances because of the fact that the case went federal pretty early. The FBI got involved in it, and basically my understanding is that they told the office to, the FBI has it, to not make any extra judicial statements on the matter. That aside, if the FBI tells the office what to do in terms of that, I'm probably going to follow that as the elected. There's a lot of not only investigative reasons for doing that, but there's also, remember, everybody's entitled to due process. Everybody has constitutional rights and that sort of thing. And by rule 3.6 and 3.8 in the rules of professional conduct, we're not to make, as prosecutors, any extrajudicial statements that could prejudice either the potential jury pool or the matter in any way, and also not to condemn somebody before they should be. Now, as far as what I would have done in this case, absent an FBI, is I would have gone forward and told what I could, but no more than the rules and due process allow.
Mr. Beggs.
So the elected prosecutor were accountable to the voters of Spokane, and they deserve to know more about what was going on earlier and what was being done to make sure it didn't happen again. I would, of course, work with the FBI, but this prosecutor's office could have announced to the public, because it was a public record, that the deputy prosecutor was on administrative leave, that the FBI was investigating, and that at some point they did a procedure which I've recommended, which is bring in the Attorney General's office to investigate so there's no conflict of interest. The public wants to hear about it first from the office, so it doesn't look like a cover-up or someone's trying to hide the ball. In this case, what we really want to know is, how did this ever happen, and what are we going to do to make sure it doesn't happen again? And I just want to go back to the last question to say that I have had no dealings with the victims in that car crash case, so I'm not sure where that's coming from.
All right, thank you to you both. So Mr. Beggs, you'll answer this next question, and it's Kip's question.
Thanks, Kristi. I'm going to ask about the Gail Gerlach case. There was a decision to charge Mr. Gerlach, who fired a weapon outside his home and struck a man who was apparently trying to steal his vehicle, with manslaughter. That case went to trial. The jury decided that Mr. Gerlach acted in self-defense, and now state taxpayers are paying, close to $200,000 on this. Do you agree with the decision to charge Mr. Gerlach with manslaughter, and would you have handled that situation any differently?
The challenge in the Gerlach case is there was the initial investigation that we heard about, that the car was going well down the road, there was not a danger, and that shots were taken then. Under those facts, there should have been a charge, and I agree with the charge. The challenge was by the time we got to trial on it, the police had not really nailed down the defendants to the statement clearly. And so they simply said, no, that didn't happen. He was right by us, it was a threat to us, and that's what they argued to the jury. And so if there's anything that I would have changed in that, it was nail it down earlier so we have those statements of the defendants, since they were willing, nailed down and documented so they couldn't change it. But the charge on the initial set of facts, that was appropriate.
All right, Mr. Haskell.
I would agree. The process that we go through when we get a completed investigation is to look at the law and what you have to prove at trial, and then determine whether or not, given a reasonable defense that could be raised, whether or not a fact finder could find guilt beyond a reasonable doubt. In this particular case, I am aware of the fact that there were some statements that were made by the defendant, Mr. Gerlach, that were suppressed by the court. That is not something necessarily that can be foreseen, because there's going to be briefing on it, there's going to be argument, and ultimately a judicial officer will make that decision. So in this case, there were some statements that might otherwise have influenced the jury another direction, but I do believe that if a set of facts, when investigated, meets the statutory requirements, and you can, again, survive the most reasonably foreseeable defense, that you allow the public to decide rather than one person.
In this particular case, the prosecuting attorney did step out and, when Mr. Gerlach was charged, make some statements. Do you think that was appropriate at that time to make those statements about why the charges were filed and what they were trying to accomplish?
Again, consistent with the rules of professional conduct, you can state what's in a public record, you can state that an investigation is ongoing, you can say that a prosecution has been instituted, but beyond that, getting into the facts, if they haven't been established, I believe the rules of professional conduct would prohibit that.
Go ahead, Mr. Biggs.
I would just say it's really important for the prosecutor to explain the law to the public of what's going on, because some people felt like, hey, if my life isn't threatened, of course I can use a gun. But what the prosecutor was explaining is that under the facts as he understood them, the car was gone. And now we have the danger to children walking in the neighborhood, and if people are simply firing guns because they're angry about their property and not to defend their lives, that's against the law in Washington. So it is important for the prosecutor to explain that, because I don't think much of the public really understood those issues. And then the confusion of which set of facts made it even harder for people.
Okay, right. You would like to use your 30-second rebuttal?
One, yes.
Okay.
And that's exactly what I've promised to do if I'm elected county prosecutor. One of the most critical roles is to get out in front of things and explain, again, everything that we can, that an investigation is going on, what the facts are that are allowable within the rules. And again, make your decision, make it public, own it, and take responsibility for it. That's what I'll do.
All right, Shawn, you'll take the next question, and Mr. Haskell, you'll answer this one first.
So now let's talk about officer-involved shootings and declaring whether they are justified or not. As you know, some members of the Spokane City Council have expressed their frustration on how that process works and the fact that it isn't timely enough. And we've also seen in other counties across the state that process goes through in a fraction of the time than it does here in Spokane County. So what do you think of that process, and what can you do, if anything, to make that faster?
Well, clearly, one of the reasons that some of the decisions have been made a little less timely is we've had a spate of officer-involved shootings lately. And I believe that the number one thing that the prosecutor owes the public, that's the public at large, the family of the deceased, as well as the officer or officers involved, is an accurate decision. I will not, as county prosecutor, sacrifice accuracy for speed. However, clearly, we can do better than we've been doing, and I intend as prosecutor to sit on those boards myself and to have my chief criminal and also my major crime supervisor as the three decision makers as to whether or not an officer-involved shooting was justified or it was not. We will make that a priority until that's done, because we do owe the public that as timely as accuracy allows. Now, in terms of whether or not the officer-involved shootings are justified, there is a standard that has to be met. Remember that process of going through the statutory basis, and I'll get to that later.
All right, Mr. Beggs.
So I have looked at a lot of the officer-involved shootings and the investigations, and the actual investigations by law enforcement happen fairly quickly. I mean, they are thorough, they want to do a good job and make sure they get it right, but they happen. The delay has been at the prosecutor's office, looking at those investigations and then making a decision one way or the other. I would propose three things. The first thing is, I will have a deputy prosecutor that is an expert on officer-involved shootings and what is legal and what is illegal, so that we have someone that's up to date on the law on that. I'm very knowledgeable as well, so I'll be able to assist. But I want a go-to person so that it gets done timely. Secondly, if it is a clear violation of the law, we of course will prosecute. If it's clearly not, we'll get rid of it as soon as we can so that the officer can get back to work. If it's a gray area though, which a lot of these are, we're going to refer it to the Attorney General's office that has a unit to do these. And then there'll be no question of bias. And finally, I'm a big supporter of coroner inquest juries, where we get that to the public and they get to see the evidence and they can make their own decision along with the prosecutors about whether there's criminal or not. They at least know what happened.
All right, your second and final rebuttal?
Second rebuttal, thank you. As far as the Attorney General goes, I called the Attorney General and I asked them, okay, exactly what kind of staffing do you have for this sort of thing? They got 4.5 people at any one time. Several of them are under contract, essentially, paid for, those positions are paid for by other state agencies. There's about a person and a half at the Attorney General's office right now on any given day to look at these sorts of situations. They just don't have the staffing. What they expect you to do is, if you can't make the call yourself, hire a special deputy or go ahead and conflict it out to another county.
All right. Yes.
Use my second
Sure.
rebuttal.
You may. 30 seconds.
So that's so interesting because in the Mariah Wright case that we were just talking about, they are using the AG's staff person for exactly that same reason. Up in Colville, there was an officer who was sexually assaulting drunk driving perpetrators, and they used that special process. I'm not talking about we're using it always, but I'm talking about we will use it earlier so that we get these decisions. Because everybody wants to know, the public wants to know what happened, the officer wants to get back on the job if he or she is exonerated, and the families also want to know. We can do better on that, way better than we have been, and when I'm elected, we will.
All right, Melissa, you have the next question, and Mr. Beggs, you'll answer this one first.
Part of this comes from what Kristi mentioned before. The first time we've had a new prosecutor in this county in 16 years, no matter which of you wins the election next week. A lot of money has been put into this race and a lot of scrutiny. Why do you think that is? And how do you think people can sort of get through all of the outside noise to get to who they should decide to vote for?
Well, I think they're going to focus on what people's qualifications are. And again, the office is an elected manager position. You have to run the whole office. So you have to be someone who's got experience creating change, supervising people, managing budgets, negotiating with other government leaders, and a long experience as a lawyer. That's what I believe the voters are going to look at. And we both have websites and Facebook pages, and people can make that. The reason it's an important case right now is that Spokane is on the cusp of a big change. For a while, we had a $200 million jail. Are we going to spend our money on that? And then we were able to convince people that, no, let's just spend our money more wisely. Let's manage our jail beds more wisely. Let's get people off the merry-go-round of jail, reoffense, jail, reoffense. And so people get that, and it's not a left or a right, or it's not a law enforcement or a non-law enforcement. Everybody wants that to happen because they know how much money we'll save and how much of a better community. And so that's why this really is the premier race in this election this time, and people are paying attention.
Mr. Haskell?
Thank you. Melissa, you raise a good point about the money. I think it's very important for the voters to take a look at the PDC records for both of us because my opponent raises a considerable amount of the total percentage of his money from out of state and out of county. And take a look at my PDC and see who's supporting me financially. It is important that the elected prosecutor have the qualifications that you're looking for. And I do have over 13 years of criminal prosecution experience. My opponent has no criminal prosecution experience. It is a management position, and I haven't been a manager in the office, but what I have done is I've gone away for active duty for 3 years, and I've been with the United States Attorney's Office. So it's important to understand that as a lieutenant colonel retired in the United States Air Force, I've had extensive military and leadership experience, and I've also led people not only in the air in flying airplanes, but also in a combat arena in Saudi Arabia when we were over there for Iraqi freedom. I'm prior elected, and I have lots of budget and other issues experience.
All right, this is going to be our last question, so we'll ask you to limit your answers to 30 seconds. Mr. Haskell, you'll answer this one first, and Kip, you have the last question.
Yeah. Washington voters are going to decide on a pair of gun initiatives, Initiative 591 and Initiative 594. Initiative 594 has to do with expanded background checks for things like online sales and gun show sales, and 591 requires that the state doesn't pass any laws that would supersede federal background checks. What is your opinion on these initiatives, and what impact would they have on the prosecutor's office?
We recently addressed this issue in another forum. 591 really is duplicative of laws that we have to protect us already. So I believe that there's no sense in putting a law in the book that's duplicative of rights and responsibilities in terms of the government already. 594, the concern for me as a prosecuting attorney is the transfer issue. It's not the registration of the sales and that sort of thing. It's not the background checks, but it's policing the transfers. I think it's almost impossible to do. It's going to be difficult to prosecute those cases, and though I will do them if it becomes the law, it's a very difficult situation.
All right, Mr. Beggs?
Yeah, I've been recognized by my peers locally and around the state as one of the top lawyers who does constitutional law. And I'm a big believer in the Bill of Rights. And every year I do at least one case that defends one of the Bill of Rights. And the Second Amendment is right up there. But what it does not protect is giving guns to a felon or someone who's been declared mentally ill. And those, we know that background checks as they exist prevent those sales every day. And 594 will do a better job of that. To the degree that it impacts on the Second Amendment, I'm going to only enforce it up to the limits of the Second Amendment, because the Supremacy Clause of the Constitution says that is the law of the land.
All right, thank you to you both. It's time for closing statements. And Mr. Haskell, we did the coin flip, and you will go first. You have 1 minute for closing statements.
All right, thank you. Thank you very much for having us here today. Thank you for everybody that's tuning in. If I'm elected your county prosecutor, and I'm asking you to do so, I will bring a strong commitment to criminal justice reform, seasoned by my 13 years as a criminal prosecuting attorney. I am not an idealist, but rather a pragmatist. I will protect the safety of the public. I will hold offenders accountable. I will and have been tough on crime. I will make sure that victims are compensated, and I will push for the reforms that are listed in the blueprint for reform, but only the ones that are proven to work, only the science-based ones, the ones that have been rigorously tested and continuously evaluated. And I will only offer those to offenders who seem likely to succeed in those. You can't make somebody take treatment that they don't want, and after a while you're using more resources on someone who won't than those who need it. Thank you for your vote.
All right, Mr. Beggs, 1 minute.
I'm running for Spokane prosecutor to reduce crime and save taxpayer money. We're currently spending over 70% of our budget on criminal justice, and we don't feel safe. We're drowning in property crime. The jail's overflowing. It's time for new leadership to solve some old problems. For 23 years as a lawyer, I've been holding wrongdoers accountable by winning jury trials, arguing to the Supreme Court, and negotiating reforms with the city and the county. I've helped create justice for victims of domestic violence, drunk driving, sexual assault, and the families whose loved ones have been killed, like the Autozem family. And with all due respect to my opponent and his service to our country, I have more experience practicing law, managing attorneys, and creating the smart justice reforms that will help us get to a safer community. Vote for Breean Beggs for Spokane County Prosecutor and be part of the solution. Thank you.
All right, thank you, gentlemen. And that'll do it for tonight's debate coverage. Our thanks to candidates Breean and Larry Haskell for taking part. And I also want to thank our panel of journalists, Shawn Chitnis, Melissa Luck, and Kip Hill. The general election is November 4th. All ballots must be postmarked on or before Election Day. Thanks for watching, everyone. Don't forget to vote.